empowered people make informed decisions that lead to living a life without regret. This is Sara Kaki and Shawna Woods from Atlanta Divorce Law Group, and this is the Happily Ever After Divorce podcast. Hello, everyone. Welcome back to the Happily Ever After Divorce podcast. I am Sara Kaki with Atlanta Divorce Law Group, joined by our managing partner, Shawna Woods. Hey, Shawna.
Hey, Sara.
All right. So I'm excited to do this one with you, Shawna, because you, I think of as a mastermind of creating strategy and working with our clients and working with our team in creating a long-term strategy, not just quick reactions in a legal case. And we're specifically talking in a divorce case. Shawna has close to 20 years of family law experience and has seen it all. And in that time frame, I think her biggest gift that she brings to the table and she brings to our firm when she works with our team and works with the client is sort of what strategy angle do we want to take in every step along the way, and how does it work with the theme of the case? Shawna, from a high level, what are some initial things you're looking at when you're talking to a client on when your mind starts thinking strategy? What are some facts or factors that impacts the strategy you're going to select?
You know, the first thing that I look at is what kind of strategy do we need?
Mm-hmm.
Okay. Strategy could be very straightforward. Someone can come to me and say, look, we have just these few things to work out. Really, we've agreed on pretty much everything, but we need a little help here and a little help there. So the strategy really is, okay, do I need to get this person with a financial advisor to decide which part of the equation, you know, that we're asking for, which part of the assets, what is the best for this person? That could be part of the strategy. It's
right.
Like, let's figure out what we want to ask for. Let's put together a uncontested packet and let's put it in front of them, right? The strategy can also be, all right, let's talk to you about how do you talk to your children?
Yeah.
Right, about the divorce, and that you want to, if possible, do it together. You know, that can be part of the strategy. So the initial conversation really is, where are you, right, in this process? One of the first things that I ask people when they come to see me is, have you talked to your spouse about what it looks like for both of you post-divorce, right? And if their answer is no, you know, I'm like, okay, so let's start here where you are. What do you think it looks like post-divorce? And a lot of people can be amicable, right? And we encourage that. Honestly, one of the things I also say is, the more you agree, the less costly, both emotionally and financially, it's going to be for you, right? And really, our goal is not to blow your case up.
Right.
And I'm not going to say that's not all attorneys' goals, right? Because I do think that there are certain attorneys out there who feed into these emotions, right? And make the case much bigger than it needs to be.
Or project their own values and
Yes.
emotions into the facts of the case.
Yes, and I do think sometimes it comes from more experienced attorneys, or sometimes it's just their personality, right? They can't separate themselves from it. So the very beginning, right, is the strategy of, what do we have here, right? Because no divorce case is exactly alike, right? There's times where I'm like, okay, you need to go get an appraisal of the home so we can even begin these conversations if you're wanting to keep the home, right? So it really does depend on what we have coming in the door. There is no cookie cutter strategy for any particular case. What works with your neighbor's case, what works with your cousin's case, what worked with, you know, your last divorce case isn't necessarily going to work with this case, because you're dealing with two different people. And we had some conversations before, Sara, about toxic individuals or being in a toxic relationship, right? That two people, they have to take ownership. And if you have been in a toxic relationship, what makes you think your divorce is going to be amicable?
Right.
Right. And I think that's a big consideration, is how were you in the marriage is going to be reflective of how you're going to experience this divorce.
So let's talk about that, because so often our clients come to us and they're already pretty set in their mind of the strategy. So a lot of them are, or the couple has already discussed amongst themselves and they've been set on a strategy. And one thing I find interesting is what turns an uncontested amicable divorce, right? Because we see this happen all the time where both parties had agreed this was going to be friendly, this is going to be amicable. What turns that into bigger than it needed to be? Of course, you hit on one already, which is the selection of the attorney. It turns out it's an attorney that has their own projected feelings on this, or for instance, if we have a case of infidelity, maybe the couple has come to terms with that infidelity and moved past it, but the attorney themselves has such strong beliefs about it and they can't get past that and they project that onto the case. There's a lot of that happening. But when they're coming to us and they're presenting a strategy to us and they're saying, we've agreed on an amicable divorce, this is what we want to do. What are considerations you have to not let that thing blow up and let that divorce remain amicable? Because so often we do see it blow up. What happens that an amicable divorce blows up in the client's face?
Yeah, that's a great question. And I want to be very clear about what uncontested means, because a lot of people have the misconception that uncontested means that they both agree they want the divorce, right? That's not what this is. An uncontested divorce is that we're able to reach resolution before we file with the court. That doesn't mean we've agreed on everything that first minute. Right. It means that we worked through the hard stuff, and that's going to require this is very important, that's going to require that both people have full and access to what the assets or debts are. And they understand, I know what all you have in your name. I know what all I have in my name. We have been a full and fair disclosure with each other so that we can really talk through what does this look like. But because Georgia is what we call equitable division, right? Which means what's fair. What's fair in one person's mind is completely not fair in the other person's mind, right? And so oftentimes we'll see, well, it's fair for me to keep the house because X, Y, Z, PDQ, but they really can't afford to keep the house. And so now they're feeling like, okay, this is unfair, right? And that will turn into a bigger argument. Yeah. Okay, so why is it unfair, right? Or, parenting time. Right? What is a good sharing relationship parenting time? And I think that a big factor in when we think, okay, what's the resolution here, is when people are really taking it, and I think we've done kind of some exploring of this before, is people really feeling like the victim in it, and that's when they start feeling this is unfair to me, right? Yeah. And so I think that really does change things, right, from a contested or an uncontested to a contested. But a big factor is the other side doing that as well? Is the other side looking at something that's not realistic, right? They want a 50-50 sharing custodial relationship, but they're a Delta pilot. Yeah. Those two things don't go together, right? But and they come across as, well, then I want you to work around my schedule and have the kids work around my schedule. That might not be what's great for the kids, right? And so it's those real conversations of, this isn't going to be picture perfect for you. You're not getting everything you want. There's going to be compromise if you want to come into this as an uncontested divorce. But I also want to be clear that just because we file it as a contested divorce does not mean it can't be amicable. Right. It just means we need something from the court before we can proceed, right?
So I think if you are coming into a divorce where you've met and you've discussed openly amongst each other, and you're hoping that the strategy can also be a amicable approach, whether it's uncontested or not, but one that is smooth and doesn't involve necessarily doesn't involve litigation. I think a couple of things is important is A, we're both parties truly honest with each other about all the facts. Because we do see some of the things I've seen where an uncontested divorce blows up to be more is we have a spouse that comes to us that has the higher asset list and controls the assets. And it really quickly wants a quick and easy, smooth, amicable divorce before they're driven through financial discovery and the whole gauntlet. And then the other side, somewhere along the line, to Shawna's point, starts feeling insecure about what is being shared, whether they're having family whisper in their ear, whether they've hired an attorney that tells them, projects into them that you need to be doing more. I think that's why it's so important that who you speak to, whoever your attorney is, they bring you into the strategy conversation. You are part of the strategy conversation with them versus being cookie fed a strategy, or the attorney is building a strategy in their head based on their own belief system and their own values and their own priorities. One thing we always talk to our clients about when we're building strategy with them is he could have more. You're right. There could be a lot more assets you're unaware of. So do you want to be done? What's more important? Being done in the next few months and getting enough for the vision, the budget you've created for yourself personally, or to know that you uncovered every stone? And neither answer is wrong or right. It's a completely personal decision, right?
Absolutely. The key point that I tell so many people is that this is your life.
Yep.
This is your case. This is your divorce. Your attorneys are there to advocate for you. Your attorneys are there to advise you. They're there to guide you through this. They are not there to control you and tell you what to do. And so many times in cases I hear, and this is just nails on a chalkboard for me, when an attorney will say, can you control your client?
Yeah.
This isn't about controlling.
This is an
client.
adult.
This is about me advising my client and letting them, you get to make the choices, right? And there are a lot of times I'll say, I think there's more on the table here. And somebody will, and I say a lot, maybe a handful of times, there's more on the table. I'm okay with what I have.
Yeah.
Right? But that's their decision.
We're just here to make sure their decision is an empowered and informed one.
Exactly.
And that they've assessed the complete risk. And they've assessed the return, and they've assessed the cost benefit. But ultimately, you could have a client that 10 years after a divorce would look themselves in the mirror. Again, we talk about living without regret, and has this bug in their stomach that says, I didn't go for what I should have. I sold myself short. The attorney didn't advise me there was more. The attorney didn't fight for me hard enough. I didn't fight for myself hard enough.
Right.
I didn't get what I was worth, right? That could, and you need to think about that when you're deciding your strategy. You could also have somebody look themselves in the mirror and say, we went through the whole process. We did the discovery. I dealt with attorneys for months. We fought for months, and I got the true 50-50, but I'm exhausted and I'm miserable, and I wish I could take that time back, right? And that's also a valid point that we as attorneys need to consider. And when we do these strategy sessions with our clients, we bring forth both images to them and say, which one do you relate to? Which person in the mirror do you relate to?
Exactly. And as an attorney and as someone who's litigated for so many years, to me, I'm always, the advocate who's like, but here's what you're entitled to, right? And I want to make sure that they know, here's all the avenues. And there are certain, things that we need to put in the settlement agreement that as attorneys, we know that says if somebody's hiding assets, that we get to reclaim it, and we have to put that in the settlement agreement. There's certain things that, you definitely want to point out to your clients that they're not thinking about right now. Right. Because they haven't been doing this
and
for 19 years.
And they hired you to think about this.
That's what they hired us to think about. They hired us for our expertise and to advise them. And I think the advice part is the important part that a lot of the attorneys miss, is that, again, don't just look for the kill as an attorney. Don't just look for that win. You really have to look at this person as a whole, like we talked about, the holistic individual. And, I tell people, I say, you have to be mentally and, physically ready for this. This is going to be hard. Yeah. And you need to get yourself there. That's why we send them to therapy so often, so that we can help people through this process. And it can be a difficult process, but it doesn't have to be as emotionally draining as if you have somebody pushing you in a direction you don't want to go.
And this is what drives me just as crazy as the attorney that wants to go for the kill. that projects the fight, that projects
Right.
their own value system and their own belief system and their own, fight strategy book, is the attorney that also on the other side of on the other side of it is saying, well, this isn't really worth fighting for.
Right.
You shouldn't fight over this. That's for your peace of mind, for your mental health, for yada, yada, yada. Let go of these things. These aren't really important, right? Or just let's agree to settle. You'll be much happier this way. I think that is just as irresponsible and just as much projecting an attorney's own stuff onto the client as is the attorney that just wants to go to court and wants to go for the fight and wants to go for blow up the case. It's irresponsible. This client could literally have something emotionally tied to for once in their life saying, I stood up for myself, or I wasn't fooled, right?
Right.
Or I wasn't tricked. It could be an important part of their journey to say, I did everything I could. I put up a fight for myself.
It is really, really important to have the attorney who says, at the end of the day, if we need to go to court, I'm ready, willing, and able to go to court and advocate for you. And a lot of times if we've had somebody who's in a really controlling relationship, right, they're going to have to end up in court. And if they have that attorney who's like, oh, let's just agree, they're going to give away the farm.
Yeah.
Right. And you don't want either one. Right. Another thing that I like to talk about is, I don't like it when people say, oh, you're a bulldog. Well, a bulldog just wants to fight. That's all they want to do, right? And then you have the bulldog and you have the sheep, and the sheep just wants to go along, right? And they just like, okay, come on, let's just everybody get along and hold hands and we're going to get there eventually. Well, sometimes that doesn't happen.
Yeah.
So you really have to have what I call the fox attorney, right? They know when to play the bulldog and they know when to play the sheep and they know how to move your case forward, right? And making sure that you have, and I really do say, in your arsenal, right? In your arsenal, you have somebody who at the end of the day says, I'm not afraid to take this to court. Let's go.
Yeah.
Right.
And that segues me into, because we just talked about coming in, wanting an amicable approach for hopefully what is an uncontested divorce or a divorce that reaches a settlement and doesn't go through the whole litigation or divorce process. What about the person that comes in and they're not sure either way, which way it's going to go? Kind of what factors, what do you use then? How much legal strategy, case building do you do when they're sort of like, listen, this could either turn out ugly, he or she could take it badly, or he or she may, I don't know, we've grown apart, we haven't talked in a while, he or she may be in a different place now because they're dating someone or their priorities are different.
I think you have to start every case, even when somebody comes in and says they're amicable, but especially when they don't know. I think you have to start every case with, okay, I will prepare as if this is going to go to litigation, right? I'm going to prepare in the beginning for advocating for my client, for understanding their story. And I think it's a huge part of it. Because if it does end up in litigation, we're telling their story. We're telling their side of this relationship and this story, whether they're coming from a place of a controlling partner, whether they're coming from someone who decided to give up, right, and not participate in the relationship, or we're talking about custody and who's, the proper parent to be the primary parent. We really have to get into what their story is, and that's gathering information from the very beginning and being ready. If this does go into a way that we don't want to, but being ready and having that preparedness makes you better in negotiations.
Yes.
Right? Because now you know the information and now you're ready to advocate at every step along the way. So the strategy really is, again, we start with, what are your goals? Right? That's one of the key questions we ask somebody to come in. What are your goals? And sometimes the goal is, I want to keep the house, or my main focus is primary custody of the children. It's like, okay, let's focus on what your goals are and then develop the strategy of how to get those after that. And
that over preparation that we're talking about, I think it's what we both have seen so often is it can turn a case that is uncontested or is amicable that could blow up if you're not prepared for it. It can keep it at bay, and we'll talk about that. It can prepare a case that you're not sure yet which direction it's going to go. It could kind of force its hand to go in a more amicable direction. Mm-hmm. And obviously, if you have a highly litigious case, you want to be on the forefront of the trial schedule. You want to be forefront of the narrative and the story of the case, the theme of the case.
Exactly.
By the over preparation. So first, let's talk about an amicable case. Okay. You have a client that comes and says, Shawna, I don't think you need to do all that much in this. Like everything's pretty, we've agreed on everything. And I don't really want to spend much time on you guys having to do anything. Tell me about why you would advise that client, say, we do need to do some preparation here. Tell us about how preparation can actually keep an amicable case amicable.
Absolutely. I think a lot of times when you don't do the preparation, the client comes in and it's very, and again, I'm very much about empowering this client. This is absolutely your case. But I want to inform them and advise them properly in that if we don't have that information, if we don't have that as we head into these negotiations, as we head into this mediation, we're not prepared. Mm-hmm. And when we're met on the other side with, just happened the other day, we're met on the other side with this sudden, oh, by the way, here's this sneaky thing that you didn't know I was going to pull because you didn't know I really was doing this on the side, you're unprepared. Yeah. And you're going to settle for things that you shouldn't settle for because you don't have that answer, because you don't have that counter, because you haven't developed your story. And it doesn't mean that you have to spend tons of money in the beginning. It's a process along the way. Too many times I see attorneys who really with good intentions and good hearts saying, look, this is, we're all gonna hold hands. We're all going to be amicable. And then the case falls apart and the client does not feel like they were well represented, right? Because they're looking at the attorney going, well, you knew it could have fallen apart.
And that's the trouble with the whole amicable mindset. Not trouble, but it's a pitfall to be aware of.
Potential downfall. It's not that we're not being amicable. We're being amicable and we're being realist.
Right. Right. It's actually making sure that this thing really sees through amicable by preparing and being prepared. If you prepare for something to blow up, then you can always assess the risk and make sure it stays amicable. Whereas if you're sitting back and you're just being reactive to the fact that, okay, I just put my trust as amicable. It's going to settle. It's going to be fine. Something blows up. Now you really have a fire in your hands and you don't have answers. Now you're trying to catch up. And by that point, this thing could have gone completely out of hand.
By that time, it's usually too late. Think of it as defensive driving class. Yeah. Right? You're not out there looking for a crash, but you're going to know how to avoid one when it comes to you. Right?
Yep. And then talk about how cases can actually, when you prepare it as it's going to court, how you have those cases that may blow up or have already blown up, how they have a higher tendency to settle when your legal team actually prepares it for trial.
I cannot tell you how many times when I've walked into mediation or even just a negotiation conference, I'm prepared with all of the documents. I've got my marital balance sheet. I know what I want to ask for because I've talked with a financial advisor about which one's the best to ask for my particular client based on their goals moving forward. Right. I've already prepared a full-on parenting plan with reasons over here on the side why my parenting plan is better than their parenting plan, right? We've already put all of this into place. We've already worked with our client to walk in and say, we're ready, right? And here are the reasons. So when we're negotiating, it makes sense, right? We've got our story. We're telling you why this is best. And the other person's just not prepared or not prepared as well. Yeah. And they can't justify it. They don't like it, but they don't know why or can't articulate it. And they don't want to go to court against that. And they don't want to get a court against that. That is a very important thing is when you come in and you are that prepared, it's a aha moment if the other side is not.
Yes. And usually these things, they're not.
Right.
They're banking on both parties just coming in and reacting.
Right. I can't tell you how many times I've been in mediation and the other party has just shown up, attorney or not, just shown up. And they're like, oh, we'll work it all out here. It's like, no, we've already worked it out.
Yeah.
Our goal is getting you on board to where we are.
And I think it's interesting because people think, oh, I'm going to go amicable so I can take it all simple and sort of react to what's coming and going and laid back. I actually think an amicable divorce that has the highest potential for staying amicable and settling quickly and smoothly, it's time sensitive. Because that feeling of being amicable has such a small window until a life stressor happens in the couple's life that makes them, because they're separating. There's still some feelings there that are hard to navigate through. Yes. So it's time sensitive and it requires diligent preparation so that if there is a moment of shock or there's a moment of something's been left behind or my gut is worried about this, it's all on the table and we see it. And it becomes crystal clear that trial is not necessary because we've sorted it all out.
Absolutely. And having met with the client beforehand and preparing them for that mediation and say, oh, here's different scenarios how mediation goes, right? Yeah. So that they're prepared to go in there and knowing that I can make this decision today. I've talked to my attorney. We've walked through the different strategies. We've walked through the different power. We know where my trigger is as far as I'm not going past that point, so that you feel empowered to make these decisions going in. When you walk in as like, oh, okay, well, we've always been nice, so we'll be nice here. There's a saying that you don't really know anybody until you met them in court, and that's really true.
You leave a lot of room for chance.
You leave a lot of room for chance. Of course, everybody wants to do this in the most efficient way possible. And the most efficient way possible is to be prepared.
And in a trial case or in a case that has potential to blow up, what I'm hearing you say and what we know and we preach is the preparation can actually reach it to settlement because it's a power move. It's a power move. Absolutely. And we're in charge of the narrative and we're going to be in charge of the schedule. You need to think twice before you want to go toe to toe to this.
Absolutely. And I will tell you, 80% of cases can and should settle without having to go through full litigation. Yeah. Right? They really do. And anyone who doesn't have that kind of record may be pushing their cases to trial. And you got to watch out for that as well. But hands down, Sarah, you nailed it. If you want this to be amicable, you go in there with a, what is it? Carry a big stick and walk kindly?
Yes.
kind of attitude.
You need to be a leader in it.
You
need to step up as a leader in it. Here are the facts. Here's the information. Here is the amount of preparation at the end of it. It gives all parties a safe sense of there is a leader in this. Yes. It brings sort of soundness to the chaos. Mm-hmm. It brings security in that the facts are out and about. Just because we're amicable doesn't mean we're, lottie-dying through everything and creating something very generalized and not taking this seriously. Just because it's amicable doesn't mean we're not taking it seriously. But the bottom line of what we're saying here is whichever strategy you want to select, it needs to be selected with you talking to your attorney about who are the players in this marriage, from the children to the advisors to the character of your spouse. And that really drives strategy quite a bit. And so does what are your priorities, right? Exactly. What are your priorities? What is the characters here? What are we working with? And then making sure you select an attorney that lets you in on the team of building strategy. You're on the team building strategy and they've listened to your priorities and you're not getting a divorce that has the attorney's priorities in there.
We're in this together.
Yes.
Right. And at the end of the day, they go home to their families and we go home to ours and we all have to feel like I did my best today to give it my all. Each strategy is just a little bit different for each family.
And sometimes it can make a big difference and sometimes it doesn't make that much of a difference, but we don't know until we let the client
make those decisions.
Yeah. Thank you, Shawna.
Thank you.
Thanks for listening to the Happily Ever After Divorce Podcast. If you'd like to learn more, go to atlantadivorcelawgroup.com/resources.